Good Saturday morning to everybody, and welcome to Legal Notes with Mary Ann Charron and Ned Barron from Charter Oak Law Group. I'm Gary Byron. Hey, folks, how's it going?
Good morning.
Fantastic.
This morning, then, we're going to talk, I guess we're going to talk about end-of-life decisions in incapacity.
Yeah.
Wow. So what do we mean? When you say end of life, that can mean a lot of different things to me.
Yeah.
How would you describe end of life?
Why don't you go first on that one?
Well, I think in general terms that when we talk about end of life, it's not that there's an emergent situation that's happening, but more that there's been due to age, there's been a long, slow decline.
Yep.
And so now you're faced with, well, what happens if you have a heart attack? What happens? What happens if you go in?
That.
Well, no, but that raises the issue of one of the things we're going to talk about, which is a DNR.
Yep.
Right.
Yep.
So, what's a DNR? A do not resuscitate.
Right.
It's an order that is entered into between, or a document that's signed by a patient and a doctor. It's prepared by the doctor, or at least he has the form, and he has that discussion with his patient to say, you're aged, you have these medical conditions going on. If you did have a heart attack or went into respiratory distress, do you want to be resuscitated? Do you want, is your quality of life at the place where you want to continue on, or would you rather just die of natural causes, so to speak?
So do you understand that's the import of a DNR? Now, attorneys don't draft DNRs, as Ned said, that you would go to your doctor for it, but it's like, let me be.
Are there different levels, though, of DNR where a lot more effort could be put into one to resuscitate as opposed to, it's hard to do a DNR on this one. This is a very easy case where I can just, the other one is more problematic and more complex. So I can understand that one where.
I mean, we caution people about DNRs, and we try to explain the difference between what the documents we draft, which is a living will, and a DNR, right? So a living will is not the same thing as a DNR. DNRs are exactly what Ned said. You are not resuscitating that person. So you are letting them, and so the point is you want to have somebody who has capacity say, all right, I fully understand what this means, and I'm choosing, yes, to sign a DNR so that my family, my loved ones know that this is my choice, right? Sometimes it's easy when we're healthy and younger to say, oh, sure, if that happens to me, I don't want to be saved. But as we get older, you're like, oh, darn. Sorry. Don't want to swear.
You caught yourself. Yeah.
I caught myself. Oh, darn. Like, did I really mean that? Did I really mean that I don't want to be resuscitated? You can let me aspirate and die kind of thing. I mean, so the living will is I want to say is not as drastic, and it gives more flexibility to the person who is going to be making that decision for you. Right. Mm-hmm. So, Gary, if it was your wife, so something happened to you, you had a living will. The living will gives your wife, assuming that she's your agent, the ability to make the decision for you using your preferences in the living will as her guide. Yes. He disagrees with me.
I do disagree.
I don't.
Boy, maybe you two are going to go after each other.
Let's do it.
This could be a case of law and order here.
So explain the living will. How about if you do that first, and then we'll go after each other.
Okay. This is great radio here, folks. Don't go anywhere.
No.
Eat your breakfast while you're listening to the radio.
So a living will. So unlike a DNR, which as Marianne already explained, it is an end of life decision where you otherwise could be resuscitated and could quite possibly continue to live and breathing on your own. Let's say, right?
On
your heart
own.
beating on your own.
Okay.
So, but you're making the decision. No, I don't. I want to just go with natural. Just die naturally. A living will. There are one of the key components or things that have to be in place to have a living will be activated is that you have to have been determined to be in a persistent vegetative state or a permanent coma, and or you have a incurable medical condition and you're unconscious, and that without certain artificial life-saving procedures being given to you to keep you alive, then you would otherwise die in a relatively short period of time. We probably remember the cases back in the 70s of Charron Ann Quinlan and Terry Schiavo, who happened to be two women who there was some incident. I don't remember what
Terry
they
Ann
were.
Schiavo was, I think, in the early 2000s, right?
Yeah, she wasn't in the 70s.
Really?
No,
Yes.
I remember the Schiavo
Yes,
case.
Ned.
Okay. Well,
She was more recent.
Yeah.
then the Charron Ann Quinlan one is the one that I remember from being very young
That I think
and
was in
being,
the 70s.
being
Yeah.
really impressed by it. And so what happened was that that each of them had some sort of incident where they could not breathe or keep their heart going on their own. So, but because technology had developed to that point, they could be kept alive artificially by an artificial respirator or by, something that was keeping their heart going.
But for
and
go ahead. All right, sorry.
so the point is that there was no such thing as a living will before then. The question came up when you had families that were battling at that point about
There you go.
where in the case of Terry Schiavo, I know the husband said she would never want to live like this, artificially kept alive. I mean, the brain dead, nothing going on. But her parents said, yes, she would want to be kept alive. And she had nothing in writing.
Right. She did not have a living will.
Right, because there was no such thing as a living will.
No, there was.
No, there was. Sure. Yeah.
Oh, okay.
Yes, in the
This is
the
2000s,
early
there was.
this is the early
That's
2000s.
the whole point of it, was that she could have and didn't. Yeah. And so the parents were saying, in the absence of this legal document, you must keep her alive. Right. And
I remember that one.
She was able to be trained to breathe on her own, even though she was a vegetable.
Only because I remember being somewhere, and that was the topic of conversation the whole night.
Yes.
And yeah.
Well, I guess I missed the 2000s.
So you were still on the Charron Ann Quinlan one.
Well, okay.
Right? It's the bike thing. He wants to relive his youth.
He wants to go back out on the bike.
That's
Right.
it. He has missed the entire midsection. Okay.
Oh. Well, okay. So the point is that this document, the living will, allows you as the person who signs the living will to predetermine whether or not you will have those artificial life-saving procedures given to you. So to say that it's somebody else's choice to make for you, I don't agree with. I agree that once you make that choice, once you have written that choice down on a document, that you have made the decision, so you don't leave that burden on your loved ones, that you've pre-made that decision. No, if I've been determined to be in a permanent unconscious state, I'm in a permanent coma, permanent vegetative state, no brain activity, nothing going on, I either do or don't want to be kept alive artificially. That's the crux of it. And I don't think that anybody can override that and say, no, because they signed this document that said, no, do not keep me alive artificially. I don't think a doctor who has that document in their possession would allow somebody else, be it a spouse or anyone else, to come over and override the decision that the person who is now brain dead had made.
But I'm not saying that you are overriding the decision. The document specifically says, I give my agent the authority to administer or not. Now, my choice is please administer. But if you have a heart attack, all right, or you have a medically induced coma, there are certain circumstances under which, even though somebody has a life-threatening, all right, illness that is chronic, if you have someone who is in a coma or in a vegetative state, there are times when you want to say, let's just hold off and let's see. And the agent has the ability to make that decision, but it's a roadmap. I look at it as a roadmap. Because I don't know what technology today, the 70s, all right, technology didn't exist that would be allowing me to live, maybe not at my past baseline, but maybe at a way that would provide me with some, type of quality of life. And so you want to give the agent that ability to make that decision based on what you've identified as your preferences.
Well, I understand what you're saying, and the part that's missing from your analysis. Is that
this is tough.
One of the requirements for the document to become operable is that you had to have been determined to be in a persistent vegetative state. And I always say to my clients, when they have questions about it, I always say, well, think of it this way: if you're in a car accident and you have a head injury, what's going to happen, even with this document in place, what's going to happen is that they're going to treat you. They are going to, if you, at that point, if you cannot breathe on your own, they are going to intubate you. They are going to do an emergent situation. They are going to do whatever they can to keep you alive. And then you can also be on a respirator, let's say, for example, to continue to keep you alive, because your brain just had this very traumatic injury, and it takes time for swelling to go down and all that, right? So, but at some point, once the swelling has gone down, once the body has repaired itself to the extent that it could repair itself, if at that point, and we're talking it could be weeks, a month, it could be a month, it could be longer than that. But the point is at some point where the doctors say, sorry, family, this is a persistent vegetative state. If this person was going to come out of this, they would have by now. So now we're calling it. We're saying this is a permanent, persistent vegetative state. Now the document kicks in.
All right. So now it's time for a story. This is a story that you and I are both very familiar with. There are doctors, okay, who will put you, I appreciate your example, but your example is assuming that the doctor or someone at the hospital is not going to go to the family member and say, look, they're in a coma. This is what the story is. It's time to go. Before you even get to the point where you just gave in your example, because both of us had, I'm not going to say the case by name, but both of us had that. We did call him Dr. Death. But maybe that will be the teaser for you to remember.
Well, okay. That's a different application.
Oh, it is not. It is not, because that case, we had to go to court, and the son went to court with the living will and said that pull the plug on mom.
Was the son the agent?
No.
Oh, this was the fraudulent agent.
Oh.
And we had to go to court, all right, to say that she was not as bad, and you had to give her more time to live. And we had to fight that. And so my point is, you want to be able to, you think that doctors are going to give you that extended time. You think that staff is going to do all of that. And you need to be the advocate. You need to say, wait a minute. She might be in this persistent vegetative state. She might be, have a chronic condition that will kill her eventually, like cancer will, right? So you think about that. Is it really time? And that was the point of us talking about what you asked earlier. What is end of life?
Yeah.
At what point, how early is the end of life? Now you want to have a conversation because you know that there is a timeline, a trajectory, something like that. So what I'm saying is it's not a death sentence, that document. Right? It's not. But it at least allows people to say, well, look, when it really is my end of lifetime, don't worry, you don't have to keep me alive.
So the agent then, therefore, needs to really adhere to what the doctor is saying.
So that's why that's the case that Ned and I had, that we actually had to fight. Like, we hear you, doctor, but we don't think that she is at end of life at this point in time. But the doctor did say, and he testified at that hearing, that he felt it was time for her to go.
Well, so the key to that case was, and it's a very complex case, and we could spend the whole time talking about it. But the key to that was what did, what was the condition in the document that said that if I am being kept alive by artificial means, and one of those is artificial hydration or nutrition.
Yep.
So a feeding tube. And that was the key in her case. She had a feeding tube. So I'm gonna give you...
Is that a type of life support too?
It is. It's considered life support.
Absolutely.
Yeah.
Because you could not otherwise sustain your life without having that feeding tube, because you can't feed yourself. So this is a woman who had a stroke, and she had a stroke when her husband was living. The husband, even though she had this living will in place, the husband decided that she was going to get a feeding tube. And so she got a feeding tube, and she had a feeding tube for many years. And she declined slowly.
She did.
But it got to the point where she was spending most of her days, at this point she's in a nursing home, and she was spending most of her day with her eyes closed. But otherwise, she wasn't, I wouldn't say she was not in a permanent vegetative state. She was not in a coma. However, this doctor, who Marianne referred to as Dr. Death, was a neurologist.
He was.
And he went and he observed her at the request of someone. He went and observed her, and she didn't wake up for him, right? She didn't respond to him. And so his opinion was she has no quality of life, and therefore, and this feeding tube is in contravention of her living will, and so that therefore it should be pulled out, and then she should be allowed to die. Well, Marion didn't tell you that there was a daughter that was involved. She already mentioned the son. Well, the daughter was completely against this, and she comes into the hearing unbeknownst to us.
She was my client.
She was Marion's client. The woman who was the subject of this was my client.
I knew about it. We went.
Oh my goodness!
We went to the hearing.
This is how Marion and I met. Was on this case.
Oh, now I get the picture here.
So the daughter comes to the hearing.
I knew, by the way. No one else did that this was coming.
Okay. Well, she comes to the hearing, and she has a video of her interacting with her mother a couple of days before, where she has her mother brushing her own hair. Her mother is talking to her, and her mother is drinking tea. And she says to her mother, "How do you like the tea?" And she says, "Oh, it's very good." Well,
okay, so she answered the question,
right? But the point is that she plays this off of her phone in front of the judge, the doctor, the son, the conservator, and everybody freaked out. And we all had different reactions. My reaction was, "Oh my God, this is amazing. I can't believe it. This woman, she does have a quality of life. How can you say she has no quality of life? She just didn't respond to you, doctor. She responds to her daughter."
I didn't respond to that.
Right. Well, yes. But she responds to her daughter. What are we talking? Why are we even here? The reaction from the son was, "How dare you do that to my mother?" The reaction from the doctor was, "You had no right to go in there and interact with your mother." And the reaction from the conservator was, "You had no authority to give your mother, a sip of tea."
Tea.
Right?
Right.
This is a bizarre.
And Marianne and I look at each other across the table, and we're like, "Are we in?
Yeah.
What world are we in?"
Right,
because
exactly.
These people are insane. We could not understand where they were coming from, because we just saw life. We saw life happening, and we bonded with that, because it's like this is part of how what we're about is like, hey, we want our clients to live and to have full lives and stuff like that, and we're otherwise these doctors, and there were two doctors there.
Yes, there were.
Both of them were saying, "No, she should die."
Yep.
Folks, you're listening to Legal Notes with Mary Ann Charron and Ned Barron from Charter Oak Law Group. You can reach them online at charteroaklaw.com and in their office at 860-570-1229. All right, so I got to hear the end of this story. How did it?
Oh, I'm sorry. We have to wait till next week.
Oh, wow. This is like Who Shot JR here. What a cliffhanger. No, you better not, because we still have a few minutes left here. I got to know how this ends.
Poor judge, right? Because I knew that my client was coming in with the tape, and I was trying the entire time to be poker faced. Right? So you listen to all the testimony by the doctor, because that's one of the things that is nerve-wracking but can be fun and about litigation is if you have like the smoking gun, right? The whatever. And so you let them say how bad she is. And then, you know, I have my client come in with, now I have to acknowledge that if we were in Superior Court, we may have had a slight evidence issue, but we weren't. We were in probate court, and she had her phone, and we had the evidence. And I think the judge actually continued the hearing so that the Dr. Death, and the other doctor could actually try to interview her again, right?
The mother.
But she eventually, I want to say we won. I think they withdrew the application, actually.
Yeah,
because I know.
No. What happened? The judge never made a decision.
Well,
for a year, right? It was over a year that he didn't. He never issued an order.
I think that. Yeah, I mean, first of all, who wants to be? Probate judges are elected officials. Who wants to be the judge who makes an order to kill someone? Right? I mean, to have someone pull up.
That's a little extreme.
Yeah.
Well, I did represent the daughter trying to save mom's life. Okay. So, but I mean, what judge wants to make that decision? I mean, and put it in writing. So we did have some time that lapsed, and I don't know if you remember, but mom did eventually pass, but not then and not there, and was able to, I want to say, live the rest of her life in the quality of life that she had, right? And so that's my only point with regard to a living will, is that when really is the end, when we try so hard to understand, is it really time? Is it really time to say goodbye? Because we do have the medical technology and the wherewithal to sustain someone. Ned and I just talked about a case where we had family who was trying to pull the plug. All right. In her case, the life supporting treatment was food and hydration. Other times it's going to be CPR. You know, other times it's, you know, there are other...
A respirator,
and things like that, and which was what happened with Terry Schiavo. She was trained to breathe without a need for a respirator, but she was on the respirator, I want to say, for like 2 years. I mean, she was on a respirator for quite some time.
I would just think you'd want to prolong your loved one's life as long as you possibly can.
Well, certainly you do,
but then I know the quality of life, and is that person really even there if they're in vegetative state? I get it.
Yeah,
right. If there's no brain activity, then what are you preserving? Right. That's the question.
Right.
I don't know. I'm not pretending to know the answer. And that really is a really good question about, you know, you have someone in a nursing home and you say, well, they have no quality of life. But the thing that we don't see is what's their inner life like. You know, what are their thoughts?
We'll never know that. You never know.
What alternate universe?
Yeah, I mean, and there seems to be this, you know, head-to-head between medical and legal, you know, between the doctors and the lawyers.
Well, right, doctors are trained to keep you alive, right? I mean, is a
but then you have to adhere to your client's wishes at the same time. Folks, you've been listening to Legal Notes with Mary Ann Charron and Ned Barron from Charter Oak Law Group. They can be reached very easily. Just give them a call, 860-570-1229. If you'd like to schedule an appointment, 860-570-1229. I would also, and let me say this, you might want to do this first. Check out their website. It's real easy. It's www.charteroaklaw.com. Again, charteroaklaw.com. For Mary Ann Charron and Ned Barron, I'm Gary Byron. Thank you so much for listening to Legal Notes. Until next Saturday morning, have a good one, everybody. So long.